video, we're going to talk about the best interest of the child factors. Now, if you have a current custody case or divorce case, this might be a term you've already heard. And what it refers to is a set of factors that the court looks at when deciding parenting time arrangements, custody orders, and decision making. One of the first factors the court looks at is the parent's wishes. And this doesn't mean that simply because one parent wants one thing that the court is going to order that. It's just a factor the court looks at, and the court looks at why a parent might be asking something. The second factor is the child's wishes. And again, it is not the deciding factor, it's just one of many factors the court looks at if the child is sufficiently mature, and that's the key. We have a related video that discusses at what age a child can make that decision in the state of Colorado that I recommend you watch as part of our frequently asked questions series. But the short answer is there's no set age. There's not a set age at which the court will allow the child to decide that. And that's because sometimes there are issues of parental alienation, abuse and neglect, and other things that the court needs to know about and consider. The third factor is a relationship between the child and their parent, siblings, step siblings, half siblings, step parents, grandparents, anyone that they are significantly connected to. Sometimes those relationships are really important, particularly in a period of or situation of instability for a child, and we don't want to rupture those, particularly if they're very important to a child. Another factor the court considers is the child's adjustment to their home, their school, and their community. This is important when a parent may be asking to move with a child or maybe asking to switch schools. The court looks at how stable is that situation and how important are these things to the child. Everything the court looks at is what is best for the child. Another factor the court looks at is the mental and physical health of parents, of the child. Do the parents have any needs? Does the child have any needs? These are important factors that come into play when we're looking at whether to do sole parenting, joint parenting, and where the child might be best suited to live. Another factor, and this is a big one, is the party's ability to encourage a loving and healthy relationship between the child and the other parent. And sometimes this is incredibly difficult to do when there is contested issues or when there is so much anger between the parents. But it is a significant factor that comes up. And I tell clients when we have contested cases and if we have a hearing, do not disparage the other parent in court. Do not speak negatively of them. Don't put them down. It very rarely helps the case. It very rarely makes that parent who is doing the disparaging look good. The court notices it, and the one thing that probably goes to the court's mind is this parent speaking ill of the other parent in front of the child? The goal is to foster a healthy relationship. Now, the exception to this is if there's domestic violence or the child has witnessed abuse or neglect in the home. That's the exception. However, generally, the idea is that we're fostering healthy relationships between both parents and the child. This factor is linked to another factor, which is the parent's ability to put the child's needs above their own. Because when the court is looking at the best interest, everything the court is looking at and every decision is aimed at the best interest of the child, not the parents. And the hope is that the parents are also acting in the same way, putting their child's needs before their own wants and their own needs. Another factor is whether the party's past involvement shows commitment. So, for example, if there is a parent who maybe isn't exercising visitation time, hasn't been involved in the child's school, doesn't come to school conferences or activities, the court will certainly look at that past involvement to see how involved has this parent been and evaluate it in light of what that parent might be requesting or asking for parenting time and visitation. The court also looks at certain factors for decision making, and the court may look at these factors and decide joint decision making is in the best interest of the child or decide sole decision making is better for this child. One of the factors the court looks at for decision making is whether the parties can cooperate and make joint decisions. And what this means is, for example, are the parties constantly fighting about things related to the child to the point that the child isn't getting the services or their needs aren't being met, particularly doctor's visits, if the child needs academic support? Is the party's own conflict, the conflict between the parents, getting in the way of this child getting what they need? The other factors a court will look at for joint decision making is whether the party's past involvement shows an ability to make joint decisions. And this links back to the other best interest of the child factor of past involvement. How involved has this party been? Is there a history of them preventing the child's needs from being met? And another factor, or the last factor for decision making, is whether joint decision making would promote more contact between the child and each party. And the goal is we don't want to be cutting parents out of children's lives if it is not absolutely necessary for the child's best interest and the child's needs and care. It is in the child's best interest, the presumption is, to have both parents involved and have both parents involved in both visitation and seeing the child, but also involved in discussing decisions relating to what the child might need or what's in the best interest of the child. If you have more questions about best interest of the child specific to your case, please feel free to visit our site or call us at the number linked on the last page of this video. I hope this information was helpful to you, and I hope you feel empowered to go forward with your case.